I think everyone's moved in and found their digital seats. So as I said, we're thrilled to have David Simon present tonight on off-label drug innovation. Many of you will have read David's biography tonight, so I won't retread that material, but I will point to a few highlights and perhaps one or two things not on there. David is no stranger to Cambridge. He obtained his PhD here as part of CIPIL. His PhD examined a very different topic compared to what we'll hear tonight. He looked at the philosophical underpinnings of authors' rights in copyright law. David is a master of multiple aspects of law, including legal professionalism issues, ownership of data, trademark law, copyright law, and patent law. And of course, he's also just begun a post at Harvard working on ethical, legal, and regulatory challenges of digital home health. For those of you not familiar with that, it includes things like having health monitors in our homes. David brings a probing mind to all the topics he studies, often with a philosophical view or a view at a high level of abstraction that allows him to see issues that other people don't. And I think we'll hear about that tonight as David tackles two significant challenges facing modern medicine. The first is that approved drugs have many potential therapeutic uses that are never investigated for various reasons. And the second is routine practice of physicians prescribing approved drugs for unapproved uses, so-called off-label uses. I'd like to begin now, but just one more note. We'll have plenty of time for questions at the end. So as we're going, please write your questions or comments in Zoom. I'll pick all those up as we move into question time. But without further ado, David, the floor is yours, or as I suppose, the screen is yours, as it were.
Thank you, John. It was a very kind introduction. And I'm very, very happy to be back. Of course, I'd prefer to have my homecoming in person, but we make do with the situation that we have, and I'm glad to be here nonetheless. So as John mentioned, I'm going to be talking about what I've called off-label innovation. And this paper, which is available on SSRN, is forthcoming in the Georgia Law Review later this year. So I'd like to start with an example that will help illustrate the problem that I'm going to be discussing. So what you're looking at here are two patents issued by the United States Patent and Trademark Office in 1966 to DuPont Chemical Company for adamantinone and its derivatives, including the compound I'm going to be talking about, which is amantadine hydrochloride. Now, 1966 is also a significant year because that's the same year that the Food and Drug Administration, the FDA, approved amantadine hydrochloride for use as a prophylactic to treat influenza A. In other words, you take it to prevent getting the flu. 2 years later, in 1968, something interesting happened. A patient who suffered from Parkinson's disease went to see her neurologists, and she reported to them that her symptoms of Parkinson's disease had markedly decreased. And she attributed this to the fact that she was taking a course of amantadine to prevent her from getting the flu. Now, her neurologist thought this was very interesting. And as a result, they conducted a small observational study of 163 patients. And they published that study in 1969. The results were positive, so they continued to collect data for over 350 patients during a subsequent 2-year period. And they published that study in 1972. And both of these studies show that amantadine was effective in treating symptoms of Parkinson's disease, and it was also safe. Now, in the background, DuPont had applied for FDA approval for amantadine to treat Parkinson's disease. And in 1973, the FDA approved that application. And in the ensuing years, other potential uses of amantadine hydrochloride were experimented and discovered. The drug was used by doctors to treat a variety of conditions ranging from traumatic brain injury to epilepsy, hepatitis, autism, and a number of other conditions. Yet none of these other indications, the conditions for which the drug was prescribed, ever received FDA approval. And the story of amantadine illustrates the two problems that I'm going to talk about today that John mentioned at the beginning. The first is this problem of off-label use. So one thing that might trouble you about what I've just described is that doctors were prescribing amantadine for all these other conditions that the drug was not approved to treat. They were prescribing approved drugs for unapproved uses. This practice is called off-label use, but it's actually quite common. Some estimates peg the rate of off-label prescriptions at around 20%. In some practice areas, it's almost 80%. And the reason it's so common is in part because there's a need for it. Some conditions, particularly cancers or some patients like children, simply don't have on-label treatments. And so doctors have to extrapolate from the on-label use to the off-label use. They need to figure out a way to treat patients that don't have any on-label treatments. In other cases, the off-label use is actually the standard of care. So over time, physicians have discovered that a particular drug might be useful to treat a condition the drug wasn't approved to treat. And it's so effective that it becomes the standard practice of physicians. Of course, while it's necessary, it's also problematic. It's problematic for several reasons. First, it can harm patients, right? If you don't have the safety and efficacy data to support an off-label use, patient might have side effects, some adverse event, potentially serious adverse event. They might become addicted to the drug, or they might just get a drug that doesn't work and they're wasting money. There's also a harm to the entities that pay for the drugs, whether that's public insurance in the United States, like Medicare and Medicaid, or private insurance companies. They might be paying for drugs that do harm, that might induce further medical care, or they might be paying for drugs that simply don't work. Either way, they're spending money that they don't want to spend. And finally, it can have perverse incentives for pharmaceutical companies to seek out and develop off-label uses, which I will talk about in a moment. And that relates to this second problem, the problem of new uses. The second issue is thinking back to the example of amantadine. Why weren't the uses of amantadine for traumatic brain injury, epilepsy, Jacob-Creutzfeldt's disease, and other diseases explored? Why didn't companies invest in clinical trials to see whether the drug actually worked to treat those conditions? The answer has to do with market incentives. So drug companies typically don't have adequate incentives to invest in new uses of existing drugs once their patents or regulatory exclusivities expire. So patents, just to review, provide the inventor the right to stop others from making, using, selling, or offering to sell their invention. In this case, amantadine hydrochloride, the patent covered essentially the chemical entity that went into the drug. Regulatory exclusivities, on the other hand, allow drug companies to prevent market entry by competing players. When either of those two things expire or don't exist, generic drugs can enter the market. And when generic drugs enter the market in the United States, they will be prescribed anytime the brand name drug is prescribed by a doctor. Those generic drugs will be substituted in. So suppose that DuPont had investigated amantadine to treat traumatic brain injury and conducted clinical trials and spent money, and they found that it actually worked. Their patent expires in 1983, and a generic comes on the market and seeks an approval as a generic drug to treat Parkinson's. Well, suppose a doctor then prescribes the drug to treat traumatic brain injury. What happens? Practically speaking, the patient goes to the pharmacy and the pharmacist fills the prescription for traumatic brain injury, the treatment for traumatic brain injury, with a generic drug. This means that DuPont is not going to be able to recoup its investment costs. And if DuPont wants to sue the generic drug maker for various reasons in patent law, which I can talk about in the Q&A, it's going to have a very hard time doing that. So the incentives to invest in new uses of old drugs are undercut, in a sense, by generic entry. Now, why is this a problem? Well, obviously it's a problem because there are some new uses that aren't discovered, right? We know that drugs have more than one potential therapeutic use. And if we're not discovering those uses, that's an innovation loss. It's a welfare loss to society because we don't get treatments that are needed for patients. It's also bad because it's getting harder and more expensive to develop new drugs, which means the stakes are much higher, which means pharmaceutical companies are much more careful about the kinds of drugs they investigate, which means less gambling and higher costs to patients when a new drug hits the market, because firms have so much more at stake, they need to be able to charge higher prices. It's also bad because new uses are just much cheaper to research and develop. We already have safety and efficacy information for at least some aspect of the drug. We know the pharmacokinetics of the drug. So it's wasteful in the sense that it's much cheaper to develop new uses. Okay, so we have these two problems now, which I hope we understand. And there have been potential solutions to these problems that have been discussed, both of which have, many of which have merit, but they've been framed in different terms that I think are somewhat misleading. So the problem of new uses, as I described, is sort of a failure, it seems, of patent law or drug regulation. Like we have these gaps in patent law, we have these gaps in regulatory exclusivity that allow generics to usurp the market for new uses. And so some people have said the way to solve this problem is to fix the patent laws so that companies can enforce their new uses, which they have trouble doing now. Although there's a case on appeal at the Federal Circuit that is raising the possibility that they may have less trouble enforcing these dual use patents. Or maybe we make some change to how the FDA operates such that the substitution that normally occurs at the pharmacy level doesn't happen. And all of these solutions are really geared toward enforcement, and they're focused on how do we get more innovation using patent and regulatory exclusivities. Solutions to the problem of off-label use, on the other hand, tend to be focused more on safety and efficacy. The problem is doctors are prescribing off-label without sufficient information about the safety and effects of these drugs, and therefore patients are subjected to unnecessary risks of harm. And so we need to curtail that practice when it doesn't dovetail with the evidence. Now, both of these descriptions, I think, are accurate, and both of these solutions potentially could help solve some aspects of these problems. But I'm going to suggest that there is a different framing that might allow us to think of both problems in the same informational terms. So if the problem of off-label uses is about insufficient safety and efficacy of doctors prescribing approved drugs for unapproved uses, and the problem of new uses is about insufficient safety and efficacy information of new uses of existing drugs, there's a substantial informational overlap between these two problems. New uses of approved drugs, by definition, are off-label uses. Anytime a physician discovers a new use of an existing drug, it's going to be an off-label use. Therefore, safety and efficacy information about new uses will be safety and efficacy information about off-label uses. Moreover, some off-label uses will be new. That is to say, some physicians will innovate. Physicians do innovate, as they did with amantadine, in identifying new uses of old drugs. And here the information about the off-label use, as well as the discovery and its validation, is the same information that we desire about new uses. So the new use problem is the off-label use problem. So if there is this informational overlap, which can be narrowed or expanded depending on how you define off-label use, the question is, how do we get the information that we need to solve both problems? Before we get to that question, though, we need to figure out what information we need in the first place. There are really two kinds of information that we need. The first kind of information is just basic data about how drugs are being prescribed, what they're being prescribed for, and who they're being prescribed to. And I'm just going to call this incidence data. The second kind of data we need are effects data. So this would be things like adverse events, the efficacy of the drug, how patients are responding, and so on. And that can be gleaned from either patient records or observational studies, as was the case in amantadine, or more rigorous clinical trials, which were also undertaken in the case of amantadine and are undertaken in the case of any drug that receives FDA, well, almost any drug that receives FDA approval. So not only do we need that kind of information, but for it to be useful on a large scale, it has to be uniformly formatted. That is to say, if we're going to get all of this information and put it in one place and use it, it has to be able to talk to information from one place has to match information from another place in terms of formatting, so that we can do the required analysis to figure out whether drugs are effective or whether there are any new uses that have been discovered, and so on. And then finally, it's important that this information be disseminated in some way, either in a central repository, published in a decentralized fashion, or some combination of the two, so that we can analyze the data. Okay, so that's the information we need. The next question is, who has this information? Now, recent work by Rebecca Eisenberg and Nicholson Price have suggested that payers, like insurance companies, might be a good source of information for innovation purposes, because they have lots and lots of claims data. And in some cases, they have the medical records, if prior authorization was involved. I think this is a good suggestion, but I also think it's not sufficient. And the purpose of this paper was not to explore whether their suggestion is ultimately the solution to the problem of off-label use or the problem of new uses. The purpose of the paper was to explore a different solution. The idea is that the entities that have or could have this information are providers. And by providers, I mean something very broad and general. So individual physicians, medium-sized practices, hospitals, large academic research and medical centers, et cetera. It can include all of these entities or individuals. And the reason I think providers are a good source of information is because they, in the first instance, have or generate the needed information. So providers in their rawest form collect information about prescriptions. They write the prescriptions, they take symptom data, they do all of these things. And so before it's even sent to an insurance company and processed, it's collected by the providers. Second, providers have an existing electronic information structure. In the United States, a huge percentage of providers already have electronic health records. And in fact, one electronic health records provider occupies 50% of the market. So the ability to leverage those resources is significant. Moreover, large research institutions like hospitals and academic medical centers have institutional resources like pharmacy and therapeutics committees, which evaluate and track prescription use in the institution itself. And they have organized staff and resources that can be deployed to collect, analyze, organize, and disseminate information. Third, providers have institutional competence. Many providers have experience conducting observational and clinical trials, and increasingly, even small solo providers have this experience. Recent advances in technology have enabled what are called decentralized clinical trials on a much wider scale. So software applications allow individual providers to participate in clinical trials that can be taking place in up to 30 or 40 different states. Finally, I think using providers to generate this information accords with what the FDA, the Food and Drug Administration, is doing pursuant to, which is the FDA is doing pursuant to a legislative directive, which is use real world evidence to try to update drug labels. And so sort of the epitome of real world evidence is data collected from providers in electronic health records. And the FDA is currently studying how to use that. But one of the problems that this program has is that electronic health records are in many different forms, and the data has to be processed in a way to make it more usable. So one of the advantages of using providers to get the information is to try and push them to collect data in a uniform format. Okay, if you followed me this far, we know what kind of information we want. We know who has it. Now the question is, how do we get it? Well, economists typically talk about two kinds of incentives that you can use to induce individuals or entities to engage in certain behavior. One kind of incentive is called a push incentive. Push incentives are otherwise known as ex-ante incentives because the reward is given before the activity occurs. So you can think of something like tax credits or grants where money is doled out at the beginning of the project, regardless of the outcome. And pull incentives, on the other hand, are ex-post incentives, which means that money changes hands after some benchmark or goal has been met. So examples of this are prizes and things like patent law. Once you get a patent and bring it to market, then you reap the reward, but not any time before that. So the paper explores how we might use push and pull incentives to incentivize providers to engage in the kind of information generation that I've described. Now, the point of the paper is not to say push incentives are better in every case or pull incentives are better in every case. No, the point is to illustrate that either or both incentives could be used to get this information, to show that it's possible to generate the kind of information we need. And I think that's really important to point out because the dominant mode of generating this information now is either through pharmaceutical companies, which is clearly not working for new uses of existing drugs that are off patent or not subject to regulatory exclusivity, or government funding, direct government funding sponsoring clinical trials. And while that's important, it can't possibly evaluate all the potential new uses that are out there, nor can it possibly identify all the potential new uses that are out there. So what I'd like to do in the remaining time, the remaining 10 minutes, 5-10 minutes or so, is explore some possible push and pull incentives that I go through in the paper that might help us get providers to generate this information about off-label and new uses. So let's start first with push incentives, ex-ante incentives. Here I sketch out two potential push incentives, subsidies. In other words, what I want to do is pay people to generate the information that we want. And there are a variety of ways you could structure this kind of subsidy. And I review two of them just to show what the subsidy could look like. So the first is using a model based on some existing legislation that Congress passed in 2009 that paid providers to adopt electronic health records. And what I propose is you could use the same kind of system to incentivize providers to collect information about new and off-label uses. And when you do that, you can specify that providers format the information in a certain way, that they collect certain kinds of information, that they report the information in a certain way, and that they disseminate the information to the appropriate parties. Now, the current model, paid providers set amount, and if the provider opted into the system, they would get payment adjustments from Medicare. And then after a period of time, they would be penalized if they didn't comply with the program. And you can imagine, some similar system, but with respect to off-label use and new uses being implemented. The second possibility is a variant of the first. It uses a more tailored approach a point-based system that would assign points for the kind, quality, and content of information that's collected. And the general idea is that the more points that a provider acquires, the higher their payment would be. And what's nice about a point-based system is that you can set minimums and maximums according to provider capabilities. So small providers might not be able to collect as much information or as much information in as much detail as large providers. And so the minimum threshold requirements to obtain points would be lower than for large providers. At the same time, you can incentivize small providers to collect more information by assigning them bonus points or adjustments if they collect additional information. So in this way, a point-based system would allow you to tailor regulation to generate information about off-label uses in a way that respects the capabilities and economies involved in different providers' size, location, and so on. But you could easily imagine categories like prescription capture, patient follow-up, symptom tracking, outcome, and so on. And that system would essentially add up the points and have some formula for deciding how much money a provider gets as a result. Okay, so those are two examples of push incentives that I think could be useful for generating incidence data. It might be a bit more challenging to generate actionable effects data, but I think you could still get some meaningful information from them. Now, the second kind of incentive, the pull incentive, I discuss in the paper, would be designed to capture more of these effects type data, like safety and efficacy data about off-label uses, rather than the incidence data of the pull incentives. But it doesn't have to be the case. You could imagine a system where incidence data was generated from pull incentives and the reverse was true for push incentives, but that's just how I set it up in the paper to give some flavor and diversity. So the pull incentives, the ex post incentives, are pretty straightforward. Right now, the primary entities that receive rewards for developing information about pharmaceuticals are pharmaceutical companies, and they either get a patent and then use that patent after they get the FDA approval to exclude others and reap the rewards, or they get a regulatory exclusivity. But there's no similar mechanism for providers. So the thought is, well, maybe you could develop a system in which providers were incentivized to engage in clinical trials and observational studies at a larger scale by giving them some kind of prize that is normally reserved for pharmaceutical companies. You could imagine that this would be either a cash prize to be set by, after further study, or it could be a royalty on the sale of the drug in the future, paid out by the government. I imagine that this particular reward system could be implemented such that a variety of providers could collaborate their research in order to get the prize, and that each provider would be rewarded proportionate to their research contribution. Of course, that doesn't have to be the case, but something similar kind of happens in copyright law in the United States. There's a board that determines royalty rates for copyrighted licensing. And you can imagine a similar kind of board determining how much of a particular royalty a provider was entitled to. Now, one problem with this approach is that it would require a significant change to how drugs are approved, although I don't think that is necessarily a bad thing. It would require the FDA to allow providers to petition for label expansion, or maybe it would even require that the FDA sua sponte consider label expansions on its own. So those are details to be worked out, and I talk a bit about them in the paper. The other pull incentive that I discuss in the paper is a tax credit. So if you want people to engage in clinical trials and research, maybe you give them a tax break, allow them to claim a credit or take a deduction for the research, And that kind of system currently exists in the United States for orphan drugs and just for research and development generally. Now, the advantage of offering a tax credit to providers is that it ties information output directly to the money that the provider receives. So unlike the credit in the pharmaceutical industry, you never know if the pharmaceutical company is going to publish the results that it finds as a result of the research that it undergoes and obtains a credit for. But in this context, you could condition the tax credit on anything you want. You can condition it on publishing and disclosing all the data. You could have penalties associated for burying or not publishing the data. You could have investigative powers assigned to various federal agencies to make sure that all the data is being published. And if you're worried about providers engaging in research similar to pharmaceutical companies to obtain the largest reward, if you have this kind of royalty system or prize system that I set up before, you can even tailor the tax incentives such that they are most beneficial to providers that study neglected diseases and less beneficial to providers that study diseases for which there are already treatments. The downside of tax credits is that many hospitals are nonprofit institutions, and so they may not have a need for a tax credit. In other words, if their bottom line is zero, tax credit may not help them. Now, one way to correct this is to offer them what's called a refundable tax credit, so that whatever amount of money they spend in doing research and development of an off-label use, they actually get a refund from the government for that amount. It's essentially another way of giving a subsidy, but on the back end. So these are just some ideas about how to get providers to produce the data that I'm interested in, but there are potentially other ways. And there are other potential problems associated with this approach. So if you're trying to get incidence data or even effects data from medical records or from visits with patients, you have a problem with patient compliance. Patients may stop the medication. They may not go back to their doctor. I think there are very interesting possibilities for patient follow-up using apps and potentially giving patients money to enter data into their applications. There's also issues with physician and hospital and provider compliance. Well, maybe they'll opt into a system to get the money, but then later on, they will drop out of the system. And there are ways to address these problems. You can have maintenance programs. You can have some penalties for dropping out of the program. You can mandate continuing education. And then finally, there's some really significant and important opportunities to partner with FDA, Centers for Medicare and Medicaid Services, and NIH, the National Institutes of Health, to develop some more ideas about how to take this project forward. So that's all I have to say about this subject, and I look forward to your questions.
Okay, thank you, David. That was a wonderful talk. I'm sure if we were in person, there'd be a round of applause, but as it is, you're going to have to just accept the digital version of people nodding in silence. So I'd just like to remind our attendees to please put their questions into the Q&A. We've already received a few questions from Lionel Bentley. So maybe we'll begin with those while we wait for some other people to throw some up as well.